Hi everyone, welcome to the World Constitution Day 2022. My name is Paulo Henrique Ledo Peixoto. I'm professor of constitutional law, master in political and economic law from Mackenzie University and attorney at law in Brazil. Today we will talking about the constitutional mutation in Brazilian context, comment on two cases judged by the Brazilian Supreme Court. By the way, last year, I had the opportunity to write about in this book. Well, the first point to be understood is the fact that Brazilian constitution is classified as a rigid constitution. In other words, our constitution has a complex procedure for its alteration, more than ordinary laws. For that, it's necessary a quorum of 3/5 in two terms in both houses of the National Congress. This is a normal and formal procedure that demands political will. However, as doctrine as jurisprudence accept another form to change the Constitution. It's the constitutional mutation. Here we have a silent chant because the text of the Constitution remains intact, but the norm, or rather the interpretation of the norm, is modified. This change occurs through the interpretation given to the text, what is done by judiciary when judging a particular case. Everything I said, it's the base of the theory. The big problem with this type of chant is the limit between interpreting the law or creating the law. In the second case, the judiciary would be acting as the legislative power. Now, I present to you two cases judged by Supreme Court. First one, same-sex state union. The Brazilian Constitution expressly provides that the stable union occurs between a man and a woman. However, the Supreme Court decided that despite the prediction, the concept should be expanded to also cover same-sex unions. Here, the text remains the same, but we have the protection of many relationships and country. The basis of the judgment was the principle of human dignity. As can be seen, we had the constitutional mutation as there was chant in the constitutional text. The second case, party infidelity. In this case, Brazilian constitution provides for cases of loss of parliamentary mandate, for example, criminal conviction. However, discussion arose about the possibility of losing the mandate in relation to the parliamentary who, once elected, decides to change parties. The Supreme Court, Judicial Writ, added a new loss hypothesis. It should be noted that in a situation of loss of rights, the interpretation must occur in a restrictive and no extensive manner, as was the case. Anyway, I presented this complicated situation that occurs in Brazil. I understand that constitutional mutation is a mechanism for change. However, it is essential that interpreters adhere to the principles and bases of the text. Otherwise, there will be a true violation of the separation of the powers and fundamental rights. Hope you enjoy it. Thanks. See you.